Maureen, is there any chance you could put us into a breakout room real quick, just so I can make sure the terms are correct before we put it on the record?
This is 223892LT. This is JP Property versus Lisa Gilly. May I have your appearances, please?
Kathleen Proctor, P 78404 on behalf of JP Properties.
And I'm Lisa Gilly.
Your Honor,
Thank
at
you.
this time, I do believe we have a conditional dismissal. Also, Mr. Jeremy Paul.
Wait,
who is
hold
the
on
owner
one
of the-
second. He's signaling us to wait for just one moment. And while his audio is continuing to connect, I'm not sure if Heather advised you that this case was scheduled with Judge Oakley at 9 o'clock. When she came to me this morning looking for someone to cover the case, I had a meeting and I asked her if we could push it back till 10. So I appreciate you for joining so promptly. And it appears that Mr. Paul he still has not connected. He dropped his video.
Well, Your
But
Honor,
it
I
doesn't
believe we
look-
can move forward because he's my client. And he has seen the conditional dismissal.
Okay, just give me 1 second.
Okay.
The case was scheduled this morning for hearing on a non-payment complaint. He's still not connected, but you're saying that he's not necessary for these proceedings?
No, they have both agreed to a conditional dismissal. And I've spoken to him this morning about it.
Okay,
And he has
and
approved
the
it.
terms of that conditional dismissal?
The amount outstanding of rent is $6,300. That only includes to the end of September.
I'm sorry, as soon as you turned your head, you became muffled. You said outstanding rent of $6,000.
$30. Court cost, and that is rent until September 30th. Court cost of $160. Other money due is.
I'm sorry, 160 in court costs,
Yes,
other monies due?
is $1,246.27. That is water bills. So the total amount is $7,436.26. Okay.
Okay.
Now,
One of the numbers I have is, I'm sorry, ma'am, one of the numbers I wrote down is then incorrect because the cents don't add up. $6,030 in rent, 6030 for rent.
Yep.
160 for court cost.
Yes,
And the other was $1,246.27.
yes.
That can't be, okay.
So, ma'am, I'm so sorry. So then I have the total, and maybe I got it wrong, of 7436.27.
27.
I'm
Thank
so
you.
sorry, Your Honor.
And you were saying that the other includes water and what else? Or is it just water?
Water. Okay. The further terms then are the tenant must pay $3,500 by December 30th. She's going to pay $1,800 by October 7th. That includes her October rent. She has another outstanding bill that's actually a water bill that's actually due. She's going to pay that by 10/7.
And what is the amount of the other water bill?
Your Honor, I don't exactly have it at this time. I do apologize. But it has been sent to the tenant and she knows what it
I
is.
think I got my audio back, so I apologize.
Okay,
I just had to call in with the number. I didn't
Okay,
get it
Mr.
automatically from using the Zoom app.
Jeremy,
I'm sorry.
hold on. I'm going through the terms. Okay.
Okay.
The
I just
tenant,
had an answer to the water question.
oh, okay, it's okay. The tenant must pay the remaining amount due by paying an additional $365 a month on top of her rent, which then makes her total payment is $1,800 until June 23. Then the last payment will be $160, and that is paid in July 23 on top of her rent. So she must pay the $160 on top of that. If the tenant defaults on any of these payments, an immediate writ can issue, and this is a 4B, Your Honor.
The last thing you said, this is what, ma'am?
A 4B, so we have to
Okay.
have a verifiable affidavit and then come back and ask for a writ to issue.
Okay. Ms. Kirkland,
Good morning, Your Honor.
good morning. You're in the wrong place. All I have is landlord tenant this morning. Judge Green has the criminal docket.
Okay, thank you.
Thank you. I'm sorry. I saw this attorney join. I didn't want her sitting here unnecessarily. Ms. Gilly, I'm sorry, Ms. Parak, was that the extent of the conditional dismissal?
Yes, Your Honor.
Ms. Gilly, were you able to hear the terms placed on the record this morning?
Yes, I was.
And
Yes,
just
I
so
was.
we're clear, the parties are executing a conditional dismissal that shows that through September 30th, there's rent due of $6,030. There's court costs of $160. There's outstanding water bills currently of $1,246.27, showing $7,436.27 due through September 30th. That you will pay $3,500 to JP Property by September 30th, $1,800 by October 7th, 2022, which includes the October rent. You will also pay the other water bill that, Mr. Paul, you have that dollar amount?
Yes, ma'am. It is $694.57.
$694.57 in the other water bill, not included in the 1246.27.
No, I already paid most of the 1247. What's due left is the 694.
Mr. Paul, do you agree with that?
I do.
Okay, I
Okay.
will change it to
So we need to,
694 then.
okay. So $6,030 in rent, $160 in cost, and then the other, which is the water bill, should be $694.57, period, Mr. Paul.
That's correct.
Okay. And then the remainder of the total included in the conditional dismissal, adjusted with this change in the water, Ms. Gilly will pay at $365 per month in addition to the months of rent that continue to come due. That based on the calculations done by the parties, the last payment on the conditional dismissal will be $160, which will be paid with the July 2023 rent. Is that your understanding, Ms. Gilly?
Yes,
My concern is this, does this adjustment in the water bill that's currently due, would that affect the monthly payments or the length of the monthly payments in addition to the rent? And if that's the case, if you make those adjustments before you sign the conditional dismissal, it's fine. I just don't want it to be an issue where we think that the total is $7,436 when it's actually $600 less because of the payments.
I understand what you're saying.
Okay.
I do. I'm agreeing to pay him $3,500. I'll do it today. And then I am going to go ahead and pay the rest of the $694 water bill as well this week by Friday. And then by October 7th, I will start to pay October rent of $1,800, which $365 of that will be towards what I owe him for back rent.
And how were the parties intending to execute the conditional dismissal? Were you sending it to Ms. Gilly for signature, or how were you going to do that?
I would like to send it to Ms. Gilly for signature if I can have her email address.
Okay.
If that's okay with you, Ms. Gilly.
That's fine.
What I'll indicate is that the total amount is $6,884.57. That shows the adjustment for the water bill. So however, ma'am, you adjust the payments before you send the conditional dismissal to Ms. Gilly for signature is fine. I just wanted to put some basic framework in the file because when your conditional dismissal comes in, the staff might take it to Judge Oakley, and I want him to understand what was placed on the record and that there were these adjustments. So Ms. Gilly, what will happen is, if you want to give, I'll stop talking so you can give your email address.
Lisa Gilly 77@gmail.com.
Okay, I will be happy to send that out to both parties.
Okay.
And once you sign it, you can submit it electronically to the civil department. They'll send it up for signature. And either myself or Judge Oakley will sign it and get copies back out to you. And anything else on behalf of the plaintiff this morning?
No, Your Honor, I believe that's it.
Anything else, Ms. Gilly?
No, I believe that's it.
Thank you. What will happen is if the court doesn't have something within the next 3 to 4 weeks, you'll get a notice that it's on the judge's lack of progress docket. But I can't anticipate that you won't get this reduced to writing so that we can move forward and get the case resolved. You all have an excellent day. And Mr. Paul, thank you for being so diligent and getting logged back on.
No, sorry for my technical lack of effort. Didn't work out too well, but I thank you very much. I appreciate it.
Thank you. I appreciate it. Have a good day.
Thank you.
All right. Have a good day.
You too.
You too.
So you need me to turn TV on?
Mr. Mills, can you hear me?
Okay. Yes, ma'am.
Hi, okay, the judge is, going to call the case in 1 second. I just wanted to make sure you were there.
Okay, thank you.
Thanks.
I'm sorry. No, they'll be on the screen. Yeah, that way you can see the TV better.
Good morning. You may be seated. This is 223450 LT. I'm sorry. Oh. jeez. You are not who I thought you were.
Do you want me to come
You're
in there,
fine.
Judge?
No, no, you're fine. This is Tommy Sue Schramm versus Rob Mills. Ma'am, state your name for me, please. Tommy Sue Schramm. And Mr. Mills, state your name for the record.
Robert Mills.
Thank you. Are you driving, sir?
Yes, ma'am. I'm about to be in my driveway in about 30 seconds. I just left the courthouse.
I know. They called. So where exactly are they moving that stuff to?
I'm sorry.
Where are they moving that stuff to?
I think Heather's taking some of it. I don't know where, but.
There's the one that I think is really nice, the long flat one. I would have liked that inside if she needed it. It's a nice piece, but I don't need anything else.
We can move it at
No.
night. There's a truck moving, ma'am. I'm pulling in the driveway.
Okay, my apology. I'm done driving, Your Honor.
I just don't talk while people are driving because I need your attention because we'll be going over some dates. What happened is this case was filed. It was set for hearing on August 24th and it came to me for September 7th. The case was called a 926. Mr. Mills was here. Ms. Schramm was not yet. Court dismissed the case as the plaintiff failed to appear timely. Ms. Schramm did appear at 10:15. The case had been scheduled at 9 o'clock, so the court rescheduled the matter. It was reset at a date that was not convenient not just not convenient. Mr. Mills was not available for the hearing that had been set for September 20th. So the court moved the case to this morning as a live case at 10:30. Mr. Mills presented to the court this morning, and when he submitted to screening, the security staff would not allow him into the building. So what the court did was direct him to log on to Zoom. And I was not sure from the information relayed to me if Mr. Mills was able to participate in today's proceedings or we needed to reschedule the proceedings. That being said, Mr. Mills, are you able to proceed with the court this morning?
Yes, Your Honor. I just
Okay.
informed your staff. Yes.
Sir, no, we're streaming on YouTube. Even though you're on Zoom, this is streaming on YouTube. So I'd rather not go into
Yes,
what
Your
you
Honor.
relayed to Officer Ramsey. We're fine where we are. The reason why I asked the parties to come in is because based on the complaint and the response from Mr. Mills, I wasn't quite sure what the issue was. And Mr. Mills did file a request for a did make a jury demand, and he paid the fee. Before the court schedules the matter on our jury trial date, I wanted to figure out if we could narrow the issue, figure out where we're going, and if there's truly a tribal issue, which you must have a tribal issue for the court to schedule the matter for actual trial. The court did receive the summons and complaint, which had attached to it the notice to quit for a property on Vining Road, which is a different address than appears for either the plaintiff or the defendant on the summons and complaint and the answer in response. Mr. Mills, the court could not discern what your defense was from the documents that you filed with the court. This is a pretty straightforward, seemingly straightforward termination of tenancy case. So what is your defense to this action?
Your Honor, my defense to this action is when I took possession of this property 12 years ago, it was an overgrown 1 acre vacant lot that Mother Nature had taken back. It was
Mr.
you
Mills,
could
Mr. Mills, I'm gonna stop you already because I don't want you to go into the details of the case. There is a notice to quit that is dated June the 6th, 2022, asking for return of property at 17219 Vining Road in the city of Romulus, and neither party has presented this court with anything that started the tenancy. So is
Okay.
there some written agreement between the parties?
I have a written agreement with her deceased husband, Your Honor. Yes. And to answer your question briefly, I've made every effort. This isn't a matter of me not paying my agreement. I've tried to resolve this with the plaintiff. We had an agreement to purchase this property a year ago. Ultimately, what it is she's attempting to profit from my labors and my investments on this property.
Mr. Mills, I read that in your answer. The issue for the court is that, thank you, sir. Although the plaintiff filed a request for a money judgment, the complaint is a termination of tenancy, which means that the plaintiff is just requesting the property back, and that's also what the notice to quit indicates. I have that, thank you. It asks for the return of the property on Vining Road. It's not about money. And although the plaintiff attached the list of payments and you indicate that your answer indicates that she's trying to profit from your work, it's about a termination of tenancy.
Okay, so again, the contract that I have with her husband, who is no longer with us, states that I pay the taxes on this property up until the time it is to be sold. And then I have the first right to refusal. For example, if someone offers 100,000, I can match that and stay here. And that's what the contract is and always has been. And quite frankly, that's why I feel like I'm the one that's being violated here. The property's not for sale. I offered to buy the property. I continue to pay the taxes, and that's where the improvements come in. Is the thousands of dollars I've spent here would have never been spent if I didn't have the promise that I would stay here and be able to be the one that purchased this property in the event that it goes for sale.
Okay.
There was.
I'm interrupting you for a moment because Ms. Schramm has presented to the court a unsigned 2-page document called a lease agreement entered into on February 16, 2012 between Mills Construction Services and Leonard Schramm. Is that, it's 2 pages, has not signed. It starts with this lease agreement is entered to on this date, and it ends with the surrender of the premises. Do you not have a signature page?
This is all I have, Your Honor.
Mr. Mills, do you have a full copy of the agreement between the parties?
I do. That was the first agreement that he and I had, and that was a 1-year thing. And then yes, I have an agreement signed between the parties. And that is not the agreement. I have that agreement as well, but we have a much simpler agreement signed after that year.
Okay. Mr. Mills, what the court's trying to get to still is your defense, because the termination of tenancy, the notice to quit that was sent to you, it's just a 30-day notice to surrender the property. If you have a signed agreement between the owner of the property and yourself that extends your rights beyond that of a month-to-month tenant, you haven't submitted those documents as of yet. How long would it take you to get those things over to the court?
It's going to take me going through several boxes in my basement of records. Again, I guess I was just waiting to see when the trial date was, and then I could get my witnesses and get a defense prepared. I was hoping to resolve this with Mrs. Schramm before it got to this point, so that I didn't have to spend a bunch of extra money and go to extra lengths for this defense.
See, and that's the issue. And that's
When
the
this-
issue, sir. There is a jury demand. And before this court summons 35 people here for a jury pool, we want to know that there's a tribal issue. And the next question was going to be, have you talked to Ms. Schramm, and is there some resolution possible? And that's one of the other reasons why I wanted the parties here today, to have a face-to-face conversation and see if there's any possibility of resolving this matter short of a judgment.
I would love to try to
Hold on,
resolve it.
sir. Hold on, sir.
Your Honor, my shame is that I let this go on so long. He's far behind in his payments. I pay taxes. I've had 7 complaints from the Huron Township Ordinance Officer. And I have everything on one sheet here, if you'd like to look at it.
You didn't file it as a non-payment case, ma'am. You filed it as a termination case, which is just asking for the property back. And the question right now is, are you still seeking return of the property, or is there something else you can work out with
Yes.
Mr. Mills? Okay.
He has not paid the very small monthly fee so many times that's my shame that I let it go so long.
Mr. Mills, are you able to hear her?
I barely. I had my ear to the phone.
That I looked up, and I guess that's what it was. She says that you are not paying your small monthly fee, and she's allowed it to go on for so long. She's received complaints from the Township regarding the property. So here's the thing. Mr. Mills, if you would like the jury, the court's jury date will be sometime in November. But again, I'm listening for a defense to the notice to quit. Do you have documents that extend your right to the property beyond being subject to the 30-day notice to terminate the tenancy?
Yes, and again, my contract with Mr. Leonard Schramm is I pay the taxes on this property and I have first right to refusal upon sale. And the reason I've asked for a jury is when I explain all the facts that I wanted to try to explain to you today, they're going to understand exactly what is going on here today. And again, this is not about the less than $1,000 a year that I'm obligated to pay on this property. I've been trying to pay that for months and she refuses to take the payment. She's misleading the court as to what's going on here in fact. Yes, there was a complaint that there was some debris during COVID that this place got a little bit, it did get a little bit blighty for lack of proper word. It was cleaned up. It's immaculate. And again, I know you don't want me to go into all these things. I don't.
Mr. Mills, you can, but see, this is the thing. A jury trial means that this court will be asking the parties to submit their witness list, their exhibit list, and their proposed jury instructions. The court cannot assist you in preparing for jury trial. The court would hold you to the same standards as an attorney in presenting the jury trial, but that's your absolute right to have a jury trial. I'm just not going to call a panel of 35 people. You tell me that you weren't even prepared to present the documents to me today. Even though you've had notice of this hearing and the court adjourned the hearing for you, you don't have the documents ready to present your defense. So unless and until you present a defense to a termination of tenancy case, which means a signed document from the property owner that extends your rights beyond what Ms. Schramm has presented to this court, which is the 2012 documents that says that your tenancy may be terminated by 30-day notice, which is already in the court's file. Unless you have documents that show that you have a greater right to the property, there is not a triable issue. So again, how long will it take you to go through those boxes and get the document that you think gives you a greater right in 30 days?
I'm gonna tell you it's gonna probably take, I don't know, Your Honor, a month or less. I don't know the answer. I have 13 years worth of boxes and taxes in my basement, and some of them I don't know the answer to that.
Okay.
But again, my defense is that I had not only a written but a verbal contract with the owner of this property that I have first right to refusal, and until it's for sale, that I am allowed to pay whatever the tax amount is and maintain possession of this property. I have it
But
both.
Mr. Mills,
and
Mr.
verbally.
Mills, watch this. Ms. Schramm, is there a subsequent lease agreement between either yourself and Mr. Mills or your husband and Mr. Mills that gives Mr. Mills first right of refusal?
I do not believe so. Only
See-
thing is yours, and he is over $2,000 behind in his payments. He has never paid taxes. I always pay the taxes.
Okay, Mr. Mills, where we are right now is that you do not have proof. You're saying that there's this document that exists. Ms. Schramm says that there's not a document that exists. So what this court will do is adjourn this matter for the parties to present documents. Are you the driver or are you a witness? You're just the driver, okay. We're gonna schedule a return date, and the question is, ma'am, do you have any date or time restrictions? I'm looking at the week of October the 17th.
I don't believe so.
You don't believe so? Mr. Mills, do you have some date or time restrictions the week of the 17th of October?
No, Your Honor.
Do you work outside of the home, sir?
Yes, Your Honor.
Does your work schedule prohibit you from being at the court any day or a specific time?
No, Your Honor.
If we schedule this matter for October the 17th, which is a Monday, oh, no, that's a jury trial day. Thank you for somebody else. October the 18th, which is a Tuesday at 9 a.m., would you be available? Do you need to check something before you nod your head?
I will be here.
Are you speaking to me, Your Honor?
I'm looking at Ms. Tram. I'm sorry. Now I'll turn to you, Mr. Mills. You have something that would keep you from being here in person on October the 18th at 9 a.m.
No, Your
The court staff will send notice. And the other reason why the court is going to schedule this October 18th at 9 a.m. live is that any documents that you want the court to consider, either Ms. Schramm in support of your summons and complaint, or Mr. Mills in support of your defense, will need to be here on the 18th. If you don't have the documents to present your defense, Mr. Mills, the court will find that there is no tribal issue and will not summon a jury panel. If, when we're here on the 18th, the parties are able to have a discussion and maybe resolve the case or narrow the issues for the jury, we will do it at that time. Anything else, Ms. Schramm?
Am I not to get recompense for the over $2,000 that he owes me?
We're not there yet. You filed a request for a money judgment, and we'll take that up when we get to that point, but right now, we're just not there. You're asking for a return of the property. That's how you filed the case, as a termination of tenancy to retake the premises on Vining Road. You did make a request for the money judgment, and that would be a separate part of the trial or hearing, and we'll come up with that dollar amount if that's where the evidence and the testimony takes us. Anything else, Mr. Mills?
No, Your Honor.
I'll see you here on the 18th at 9 a.m. It's the only thing that'll be scheduled in this courtroom other than arraignments. Thank you much. Have a
Thank
good
you.
day, Mr. Mills.
You too, Your Honor.
Thank you. Is that Ms. Gillis in the hallway? We're all set. You're free to go. Thank you so much. Why don't I get that same thing? Cough one more time, I'm putting you out. Hmm? Who? Ms. Bosley, I haven't seen the attorney from Mr. Katz's office. If you sit tight, I'll be back with you momentarily.
Okay.
Thank you. It's on you. You can turn it off. See? That's you. I don't leave it on me when I'm done.
morning, Mr. Katz.
Good morning.
How are you?
Oh, all right. If I can get my internet to work great.
Oh, no. Uh-oh.
No, it's all right. It's working. It should be
Okay.
working.
All right. I have three. I have Miss Bosley, Miss Lewis, and Miss Clark here. I made you co-host. Do you need to speak with them?
It can't hurt. Let me talk to each one of them. Okay. I
Okay.
will, it says create okay, so breakout rooms were not created yet.
All right, let me see here. There we go.
Okay. All right. So just take any room and just pull people
Yeah.
in?
Yeah.
Okay.
Thank you. Hi, the person who just signed on identified with iPhone. Can you hear me?
Yes,
Hi, what is your name, please?
Cornetta McKinney.
Thank you. I'm going to send you an invitation to join a breakout room so you can speak with the attorney, okay? So when you see it, just click on it.
Okay.
Thank you. Did you go in there?
I went in there and it brought me back out this way.
I'm sorry?
Yeah, I went in there and then it brought me back to this part.
Huh. Let me try it again. Can you click on it to see if you can go back in there?
Okay.
Did it happen again?
She said that she's dealing with one person at a time and she put me back. She said
Got
she'll
it.
put me.
Thank you.
Mhm.
Marianne,
Yes?
anything ready?
Mr. Katz is here. He's spoken to a couple of people and he's still in speaking with someone right now. So I guess the answer to your question, no, he's not back yet.
Jane Gillis is here.
Oh my gosh, what's she doing here?
So she's backing up Prosecutor Bailey. So I stepped out to chit chat with her. And then there was Officer Kozowski and Officer Hayes, and I had to congratulate them on the good job they did at the Pumpkin Festival. Kozowski was riding a motorcycle at the front of the parade and was very entertaining, doing figure eights and whatnot.
Oh geez, he's probably having a blast.
So I was out in the hallway doing that, and I looked at my watch, and it went from 11:02 to 11:08, and I didn't want people waiting for me. And we'll give Mr. Katz a few more minutes, and then we'll start getting going, hopefully 11:15-ish.
Okay.
Some of the cases are Mr. Burnkrantz.
The person is identified as Tyra. Is your last name Russell?
Good morning, Mr. Katz.
Good morning. You know what? I think I should be making two rooms, and let me pull people into a waiting room and then talk to people individually. I
No,
kept on throwing.
no, these are all lists of the Sarah stays.
Yeah, I thought maybe you wanted me to talk to them first. I'm okay either way. I'm ready. Whenever you are.
This is 223256 LT. This is Pinewood Circle versus Sharina Bosley.
Good morning, Your Honor. Sydney Katz on behalf of the plaintiff.
Good morning.
Turn your video on, ma'am, and state your name for the record, please.
Sharina Bosley.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place now since July 27th. 63 days have passed. Mr. Katz, has your client received either payment in full from a Sarah funding agency or notification that Ms. Bosley is ineligible for financial assistance?
I am not aware there's currently a balance that's owed, so they have not received any of that money.
Ma'am, have you received an update from the agency that you made your application for rental assistance with?
No, I talked to them last week, Saturday, and they told me that they still waiting on a caseworker and because they're behind.
Mr. Katz, how would you like to proceed with this matter?
Your Honor, at this point, we've had sufficient time under the administrative order. I am requesting a judgment. There's currently a balance due of $6,041 of past due rent, $165 of costs, for a total of $6,206, requesting a judgment in that amount with the writ to be issued after October the 10th. I'm assuming this would be as a hearing, Your Honor.
Ms. Bosley, raise your right hand for me, please, ma'am. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ma'am, you heard Mr. Katz indicate there's $6,041 in rent due and owing. Is that an accurate amount?
No.
How much rent is due and owing, ma'am?
I said it's not inaccurate.
I'm sorry?
I said it's not inaccurate.
It is the correct amount.
Yes.
Okay. Ma'am, inasmuch as more than 30 days have passed and the landlord has not received payment from the Sarah, this court is required to lift the Sarah stay. As indicated previously, we're actually 63 days past the entry of the stay. Inasmuch as you further acknowledge and admit that $6,041 in rent is due and owing, there is no tribal issue for this court. Judgment will enter showing that that is the past due amount of rent. There is $165 in cost due to the plaintiff for a total judgment of $6,206. Mr. Katz's office will submit that request to the court electronically. The court will sign it. A copy will be mailed to you. The court would suggest that once you receive your copy of the judgment, you reach out to the SARA agency and inform them that a judgment has now entered and that you have to pay or move by October 10th. That might help expedite the processing of your request. The court can't guarantee it, but at least you then put people on notice that you're facing removal from the property if the rent's not paid.
Okay,
Anything else, ma'am?
no,
Have a good day. Thank you.
you too.
Thank you, Your Honor.
This is 223278LT. This is GI&I versus Joshua Radford.
Good morning, Your Honor. City Katz on behalf of the plaintiff.
State your name for me, please, sir.
Joshua Radford.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay. Mr. Radford, stay went into place on July 27, 2022. 63 days have passed. Mr. Katz, has your client received payment in full or notification that Mr. Radford is not eligible for financial assistance?
No, not at this time, Your Honor.
Mr. Radford, have you received an update from the agency that you made your application for rental assistance with?
Yeah, they told me that I got approved for my Recert 1.
Approved in what amount, sir?
I'm looking at the email now for, it says future rent 3,742.
And when did you receive that email?
August 23rd.
Mr. Katz?
Your Honor, I'm not aware that my client has received that money, but the amount that he indicated is well below what is currently due. Your Honor, currently there's a balance of $5,088 of past due rent, $165 of costs, for a total of $5,253, which is well in excess of what is going to be covered under SARA.
Mr. Radford, raise your right hand for me, please. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Let me put your hand down. You heard Mr. Katz indicate that $5,088 in rent is due and owing. Is that an accurate amount, sir?
I will have to go talk to the front office to see if that is the accurate amount, but I'm not sure.
But what?
I'm not too sure if that is correct or if that is up to date. But I am able to cover whatever the SARA app wasn't able to cover.
If you were approved, sir, for $3,742, how long would it take you to pay the remaining balance?
Couple days just to get a cashier check.
So you have $1,511?
Yes.
Mr. Katz, are you able to go beyond the October 10th date?
Well, what I will do, Your Honor, is I will check with my client and see, do we know, Mr. Radford, based on the recertification, does it say who's receiving the funds?
Let me go to the email. As approved. Takes 2 or 3 weeks for the payment to close.
Well, the problem is we're well past the 2-3 weeks anyway.
Well, I'm not the one that sent the email. I'm just going based off what I'm reading in the email. It just says payment will be directed to your landlord.
Well, Mr. Radford, respectfully, where we are right now is we are 30 days, more than 30 days past entry of the stay, and your landlord has not received payment. That stay is lifted. Mr. Katz has, as an officer of the court, put the amount of rent due and owing in this matter, and you don't necessarily dispute it. You say you weren't sure, but today was the day and time set for entry of judgment if the Sarah Funding Agency had not paid your landlord. What the court will do is enter judgment showing that after hearing that $5,088 in rent is due and owing $165 in costs, for a total judgment of $5,253. Mr. Radford, you've indicated on the record that if Sarah pays the $3,742, you're able to pay the remaining $1,511. For that reason, if you make that payment, the court will ask Mr. Katz to not submit a request for writ if partial payment's been made. The court would like to have a hearing on this matter, which gives you, strike that. Nope. Mr. Katz, you don't even have to object. Pay that amount, sir. You'll get a
I'm willing
copy
to
of the
give an extra
judgment.
week, Your Honor. I'll give an extra
So we'll
week.
put it on the 17th.
There's the writ date, yeah.
Sir, your writ date will be October the 17th, 2022. What the court would suggest is that you make the payment that you are supposed to make, that you take the copy of the judgment that Mr. Katz's office is submit it to the Sarah Funding Agency so that they are aware of the fact that you are facing eviction if that amount's not paid. We're 5 weeks past that email date. If they said 2 to 3 weeks to send the check, Mr. Katz can check with his client for receipt of the check, and you can follow up with the agency for their submission of the check.
Okay.
Anything else, Mr. Radford?
Can I just get that hearing date one more time?
It's not a hearing date, it's a writ date. You'll have to pay or rule by October 17th.
Oh, okay, October 17th. All righty, thank you so much. I appreciate it.
Okay. You have a good day. We're all set, sir.
All right, thank you.
This is 223279 LT. This is GI&I versus Lynette McKinney.
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
Good morning.
Good morning. State your name for me, ma'am.
Quinetta McKinney.
Ms. McKinney, today is the day and time set for hearing on plans requested with the Sarah stay. The stay entered on July 27, 2022. 63 days have passed since that time. Mr. Katz, has your client received either payment in full or notification that Ms. McKinney is not eligible for financial assistance?
No, Your Honor.
Ms. McKinney, have you received an update from the agency that you made your application for assistance with?
No, I had spoke with Tom last week and he said that, that they were behind and that, I haven't had an agent that was assigned to my case, but I should follow up within a couple of days. And then I called back and I haven't got nobody, talked to anybody yet.
Mr. Katz, what's the amount of rent due and owing to your client?
Your Honor, at this time, there's currently a balance of $5,286 of past due rent, $165 of cost for a total of $5,451.
Ms. McKinney, raise your right hand for me, please, ma'am. Do you swear a firm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You were able to hear Mr. Katz just now indicate on the record that there's $5,286 in rent owing to your landlord. Is that amount correct?
I would believe so.
Ma'am, inasmuch as your landlord has not received your either payment in full or notification that you're ineligible for financial assistance and more than 30 days have passed, the court is required to lift the Sarah stay and will do that. Additionally, inasmuch as you do not object to the amount of rent due and owing, it's being $5,286 and plaintiff is entitled to the cost of $165, the court will enter a judgment for $5,451. Mr. Katz's office will submit that judgment to the court for entry, ma'am. Once you receive a copy, I would suggest that you follow up with the agency that you made your Sarah application to, advise them that judgment has now entered and that there will be a pay or move date of October 10, 2022. That might suggest to that agency that there is some urgency in getting your paperwork processed. Anything else in this case, Mr. Katz?
No, Your Honor.
Anything else, Ms. McKinney?
No, that will be all.
Thank you, ma'am. Have a good day.
You too, thank you.
Good morning, Mr. Bernkrat.
Morning, Your Honor.
How are you, sir?
I'm having trouble hearing.
I said, how are you, sir?
I'm doing just great, thank you. Although I'm having trouble hearing. How are you, Your Honor?
I'm wonderful, thank you.
Terrific.
This is 222489 LT. This is Pinewood Circle versus Desiree Clark.
Good morning, Your Honor. City Council on behalf of the plaintiff.
State your name for me, ma'am.
Desiree Clark.
Today, thank you, Ms. Clark. Today is the day and time set for a hearing on plaintiff's request to lift the Sarah stay. The stay's been in place since July 5th, 2022. 85 days have passed. Mr. Katz, have you received, or has your client received either payment in full or notification that Ms. Clark is ineligible for financial assistance?
No, Your Honor.
Ms. Clark, have you received an update from the agency that you made your Sarah application to?
No, I have not. I called and they told me that my application is still being processed. It has not been assigned to a caseworker as of yet.
Thank you. Ms. Clark, inasmuch as more than 30 days have passed and your landlord has not received either notification that you're ineligible or payment in full, this court is required to lift the Sarah stay in this matter. Mr. Katz, what is the amount of rent due and owing to your client at this time?
Your Honor, at this point, there is a balance due of $6,184 of past due rent.
I'm sorry, 6,000.
$184 of past due rent, $165 of costs, for a total of $6,349.
Ms. Clark, raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, you heard Mr. Katz indicate that there's $6,184 in rent due and owing. Is that amount correct, ma'am?
Yes.
Ma'am, inasmuch as you acknowledge that there's $6,184 in rent due and owing, there remains no tribal issue and plaintiff is entitled to entry of judgment. Mr. Katz will submit a judgment to the court that shows that $6,184. Plaintiff is also entitled to the court cost of $165 for a total judgment amount of $6,349. Once he submits it, the court will sign it. A copy will be mailed to you at the same address that appears on the notice to appear this morning. Once you receive it, the court will suggest that you submit it to the same agency you made your Sarah application to and let them know that you are now facing a pay or move date of October 10th, 2022. Although the court cannot guarantee that this will expedite processing, it at least puts the agency on notice that you are facing eviction from the property if payment is not made. If you are able to make arrangements with your landlord, or if you're able to pay some of this rent, I would suggest that you start marshaling your resources as well.
Okay. I have one
Anything
question.
else in this matter, Ms.? Yes, ma'am.
Would there, outside of the judgment being mailed, would there be a way that I could like go online or go and pick up a copy to get it sooner than receiving it by mail? So that I could provide it to, I do have a caseworker through the state as well, so that I can provide it to them for SER.
Online, it'll just say judgment entered. Once it's entered, if you come to the courthouse to get a copy, I don't know what they charge per page, Marianne, if you know for a copy.
I do not know.
Okay, Mr. Katz usually sends them in at the end of the day. They'll bring them upstairs, and so I'll sign it today or first thing tomorrow morning. So it should be available by Friday morning. If you want to come to the court on Friday and have them pull the file, I can't guarantee that it'll be ready, but more than likely it'll be ready. It'll cut out that that time for it to come in the mail for you to submit it for SER.
Okay, thank you so much.
Any other questions, Ms. Clark?
No,
Thank you, ma'am. Have a good day.
thank you.
Thank you, Your Honor.
This is 223246 LT. This is MIMG versus Kiera Page. Page.
Yes, I'm
two-
here.
Turn your video on, please, ma'am.
I am trying to get it.
And state your name for the record. Your appearance, sir?
John Burnkrant for Gateway Townhomes, MIMG.
Thank you. Today is the day and time set for hearing on plans request to lift the Sarah stay. The stay has been in place since July 27, 2022. 63 days have passed. Mr. Burnkrant, has your client received either payment or full from the Sarah agency or notification that Ms. Page is not eligible for financial assistance?
We have not.
Ms. Page, have you been in contact with the agency that you made your Sarah application to?
I have not heard anything.
Thank you. Ms. Page, inasmuch as more than 30 days have passed and your landlord has not received either payment in full or notification that you're ineligible for financial assistance, this court is required to lift the Sarah stay in this matter. Mr. Burnkrant, how much rent is currently due and owing to your client?
$4,923 plus $167 in costs for a total redemption figure of $5,090.
Ms. Page, raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ma'am, you heard Mr. Burnkrant indicate that there is $4,923 in rent due and owing. Is this the correct amount, ma'am?
Yes.
Ma'am, inasmuch as you acknowledge that that is the amount due and owing in this non-payment rent case, there is no tribal issue and plaintiff is entitled to entry of judgment in that amount. They're also entitled to their court costs of $167 for a total judgment amount of $5,090. Mr. Burnkrant's office will submit that to the court for entry. The court will sign it and a copy will be mailed to you at that Plainway address. As indicated in the previous files, ma'am, when you receive that judgment, you should reach out to the agency that you made your application to, advise them that judgment has now entered and that you have a pay or move date of October 10th, 2022. While the court cannot promise that that will expedite the processing of your application for assistance, it will at least put them on notice that you are now facing eviction if that rent is not paid. Anything else on behalf of the plaintiff?
Just simply, Your Honor, would this be by way of a hearing or a consent judgment?
By hearing, sir.
Thank you, Your Honor.
Any questions, Ms. Page?
No.
Ma'am, you have a wonderful afternoon. Thank you.
You too.
This is 223280 LT. This is GI&I versus Lewis. Barrington versus Tiara Lewis.
Yes.
State your name, please, ma'am.
Tiara Lewis.
Thank you, Ms. Lewis. Mr. Katz is here. Ma'am, today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place since July 27, 2022. If Mr. Katz does not, thank you, sir. So 63 days have passed, ma'am. Mr. Katz, has your client received? Ms. Lewis, I'm not sure what happened with Mr. Katz. I'll pass this matter momentarily. Mr. Burnkrant, we'll see if you have another matter ready. Russell. Mr. Katz, are you available? I'll take that as a no. 223251 LT. This is MIMG versus Russell.
I'm here.
State your name, ma'am. Mr. Burnkrant, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now since July 27, 2022. 63 days have passed since entry of that stay. Mr. Burnkrant, has your client received either payment in full or notification that Ms. Russell is not eligible for financial assistance?
We have not, Your Honor. We have
Ms.
not, Your
Russell,
Honor.
would you turn your video on for me, please, and advise if you have received an update from the Sarah agency? I can't hear you, ma'am.
Can you hear me now? Okay, one second. Let me get this.
Ms. Davis, I'll be calling your case next. You look ready for your, and prepared for court
Yeah,
to
I'm
be in
sorry. Can you hear
session.
me now?
Yes, ma'am.
Yes. I talked to them. They sent me an email Friday and said that they will be sending the payment over. I'm trying to go to a quiet area. I'm sorry. I had to come into work. Okay. Can you hear me?
Yes, ma'am. Just stop moving for one moment. You received an email on Friday that indicated,
I can't hear.
Ms.
Hello, can you
Russell,
hear me? Okay, I can hear you now. My microphone was
I
off.
asked you if you would just stop moving, please, for one moment. You said you received an email on Friday that indicated what?
That they will be sending the payment.
Sending a payment in what amount and to whom?
Second, I'll pull up the email. It says in the amount of $1,025 to my landlord.
Thank you. Mr. Bernkrandt, how much rent is doing owing to your client?
$814 plus $167 in court costs for a redemption figure of $981, Your Honor.
Ms. Russell,
Yes,
raise your right hand for me, ma'am. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes,
Ma'am, did you hear the attorney indicate that there is $814 in rent due and owing?
yes,
Is that an accurate amount?
yes.
Ma'am, the court is required to list the Sarah estate in as much as your landlord has not received the payment in full within the 30 days or notification that you're ineligible. To the contrary, you've indicated on the record that you've received an email that there will be $1,025 remitted to your landlord. Mr. Bernkrandt will submit a judgment to the court that shows the $814 in rent, the $167 in court costs for a total of $981. There will be a pay or move date of October 10th, 2022. Ma'am, inasmuch as you just received that email on September 23rd, I would suggest that you submit that judgment to your Sarah agency so that they know that you are now, that judgment has now been entered, and maybe that will speed up the processing of that payment to your landlord.
Okay.
Anything else on behalf of the plaintiff?
Nothing further on this matter, Your Honor. Thank you.
Anything else, Ms. Russell?
No, ma'am.
Ma'am, we're all set. Have a good day. Go back to work.
You too. Thank you.
Thank you.
Bye.
This is bye-bye. This is 223237 LT. This is Gateway Townhomes versus Amber Davis.
Good morning.
Good afternoon. State your name for me, please, ma'am.
Amber Davis.
Thank you, Ms. Davis. The court notes your appearance for the record, sir. Today is the day and time set for hearing on plans requested with the Sarah stay that went in place back on July 27, 2022. 63 days have passed since that time. Mr. Bernkrandt, has your client received either payment in full of the past due rental amount or notification that Ms. Davis is not eligible for financial assistance?
We have not, Your Honor.
Ms. Davis, have you received an update from the agency that you made your application with?
Yes, I did. On September 12th, they sent an email telling me I have been approved for $5,600 and that payment will post in 2 to 3 weeks.
2 to 3 weeks. 1, 2,
Yes,
3
ma'am.
puts us on October the 4th. Mr. Bernkrandt, how much rent is doing owing to your client?
$6,132 plus $167 in costs for a total redemption figure of $6,299, Your Honor.
Ms. Davis, are you in a position to make the payment for the difference between the $5,600 and the $6,299?
Not today, but I will be on Friday, next Friday. Not today, though.
Mr. Bernkrandt, would you please go into a breakout room with Ms. Davis and discuss that possibility of setting a payment plan for the balance, maybe in a conditional dismissal versus a judgment after hearing?
I'd be happy to, Your Honor.
I appreciate
Thank you,
that,
Your
sir.
Honor.
Thank you.
Thank you.
Miss Lewis, Tiara Lewis,
Yes.
thank you. Mr. Katz, the court called this case previously, 223280 LT. This is Barrington versus Lewis.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Today is the day and time set for a hearing on plaintiff's request to lift the Sarah stay that's been in place now since July 27, 2022. 63 days have passed since entry of that stay. Mr. Katz, has your client received either payment in full or notification that Ms. Lewis is not eligible for financial assistance?
No, Your Honor.
Ms. Lewis, have you followed up with the agency that you made your application to?
Yes, I did. I talked to my agent yesterday, and he notified me that in the process of my paperwork getting completed, that they closed the cases and that I'm not eligible.
Ma'am, inasmuch as more than 30 days have passed since the Sarah stay went into place and your landlord has not received payment in full or notification that you've been denied, this court is required to lift the Sarah stay, and we'll do that at this time. Mr. Katz, how much rent is due and owing to your client?
Your Honor, currently there's a balance due of $3,356 of past due rent, $165 of costs for a total of $3,521.
Ms. Lewis, raise your right hand for me, please, ma'am. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ma'am, you heard Mr. Katz indicate that there's $3,356 in rent due and owing. Is this the correct amount?
Yes.
Ma'am, inasmuch as you admit and acknowledge that there's $3,356 in rent due and owing, there remains no tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount and court costs of $165 for a total judgment of $3,521. The judgment will also indicate that you must pay this amount or move from the property by October 10th, 2022. Mr. Katz's office will submit that judgment to the court electronically. The court will sign it and a copy will be mailed to you at the address that appears on the summons and complaint in this matter. Anything else in this case, Mr. Katz?
No, Your Honor. Thank you.
Any questions, Ms. Lewis?
No, thank you.
Ma'am, we're all set. You have a good day. This is 223266 LT. This is Pinewood Circle versus Ebony Owell.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Ebony Owell or anyone at 34025 Pinewood Circle, unit 04204. Today is the day and time set for a hearing on plans requested with the Sarah stay that went in place back on. Ma'am, with the blue cap on, your name, please.
Aya Adams.
Miss Adams, sit tight for just one moment, please.
Thank you.
This matter was scheduled at 11 a.m. It's now 11:43 a.m. by the court's clock. Ms. Owell, having failed to appear, Mr. Katz, how would you like to proceed?
Your Honor, it's actually Miss Powell. It's Ebony Powell. I was looking around for an OL on mine and
Ebony Powell. It's correct on the summons complaint and the demand for possession. The court processed it as missing a P. Ebony Powell. Does that change the posture of the case? Let's look.
no, it does not, Your Honor. She's missed
There's
both
no
of
one of
those
the
parties owe
participants.
money.
Ms. Powell has failed to appear this morning. The error in the naming of the defendant is due to the court and not to the plaintiff. The court's going through to make sure that the paperwork correctly identifies the tenant, and it does. Based on her failure to appear this afternoon, Mr. Katz, how would you like to proceed?
Your Honor, at this time requesting a default judgment, there's currently a balance due of $5,475 of past due rent, $165 of cost for a total of $5,640. Requesting a default judgment in that amount with a writ to be issued after October the 10th.
Thank you. Defendant having failed to appear is directed by this court. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $5,475, $165 in court costs for a total judgment of $5,640. Plaintiff's office will submit that judgment to the court for entry. Mr. Katz,
Thank
you
you,
have one more, 223284 LT. This is GI&I Barrington versus versus Charnita Purnell. Ms. Purnell, or anyone from 35511 Stephanie Street, Unit 04107. Today was a time set for hearing on plans request to lift the Sarah stay. That stay went into place on July 27, 2022. More than 30 days have passed. The matter was scheduled for 11:15. It's now 11:45 by this court's clock. Charnita Purnell. Defendant having failed to appear, Mr. Katz, how would you like to proceed?
Your Honor, at this time requesting its default judgment. Currently, there's a balance due of $3,613 of past due rent, $165 of costs for a total of $3,778. Requesting its default judgment with that amount with the writ to be issued after October the 10th.
Defendant having failed to appear, default judgment shall enter in this matter, rent to retain $3,613, $165 in court costs for a total judgment of $3,778, writ date of October 10th, 2022. Anything else in this matter, Mr. Katz?
Nope, I think we're good. Thank you, Your Honor.
And I think that concludes your docket with this court this afternoon, sir.
I believe so. Thank you, Your Honor. Have a good day.
Have a good day. Mr. Morton.
Hello, Your Honor.
Okay. Just the one strike. There was a bug. There was this 221690 LT. This is Trilogy Residences versus Alexis Baker.
I'm here, Your Honor.
Good morning. Is it still morning? Good morning.
Good morning.
State your name for the record, ma'am.
Alexis Baker.
Thank you. Today is the day and time set for hearing on plans request to lift the Sarah stay. Mr. Morton, the court notes your appearance for the record. Stay has been in place since May 11, 2022. 140 days have passed since entry of that stay. Mr. Morton, has your client received either payment in full or notification that Ms. Baker is not eligible for financial assistance?
No, Your Honor.
Ms. Baker, have you received an update from the agency that you made your Sarah application with?
No, it is still in processing. There was a holdup from the rental property. They're requesting certain documents that, like a ledger, that they needed me to come in and grab. And unfortunately, I was on a temporary work and I had no way of getting there during open hours, and they refused to send it to my caseworker. And that held up the process of it getting submitted to the agency. It is now in processing as of the 20th.
I'm sorry, the ledger was submitted on the 20th?
Yeah, I was able to finally get it because my temporary work was finished. My caseworker was trying to work with the rental property to get the ledger for like months, and they refused to send it to my caseworker. I have proof of that via email. They refused to send it to her. The only way they said I could come in was to actually walk in and grab it. Their offices are only open from 10 a.m. to 6 p.m. and I worked 7 a.m. to 7 p.m. every day. I was on temporary work and it was mandatory overtime. So I had no way of coming in and grabbing it.
Mr. Morton, do you have any information in this matter?
No, Your Honor, according to my knowledge, Your Honor, I know that this matter was stayed back on, back in May. I also know that there's a current balance due on this account of over $9,000. Your Honor, at this time, there's a large balance due. It doesn't seem, so we would request the judgment be entered. If the court wants to provide some additional time based on the alleged delay, leave that to the court's discretion.
What is the amount of rent due and owing, Mr. Morton?
Rents retained as of today's date, Your Honor, is $8,963.91. Court costs are $164 for a total of $9,127.91.
Ms. Baker, given that the ledger was just submitted a week ago, did they give you any idea of how long it would take to process your request?
They said it could take up to 30 days for it to fully get processed. Also, I like to state that I gave all my side of the information months prior when the case was first filed, and they have been working with the rental property to get their half of the information, and they're what held up the actual processing and submission because they refused to hand over the ledger to my caseworker.
Ooh, you petty.
Ms. Baker, raise your right hand for me, please, ma'am. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ma'am, you
Okay.
heard Mr. Morton indicate that there's $8,963.91 in rent due and owing. Is that an accurate amount, ma'am?
Yes.
Ma'am, inasmuch as 140 days have passed since entry of the stay, the court is required to lift the stay. And as much as you admit and acknowledge that the rent due and owing is $8,963.91 is accurate, there remains no triable issue. Mr. Morton's office is entitled to entry of judgment with that rental amount and court cost of $164 for a total judgment of $9,127.91. Although the typical writ date would be October the 10th, Mr. Morton, inasmuch as Ms. Baker indicates that there was some difficulty in getting the necessary documents from your client, are you authorized to allow any additional time for payment in this matter?
Not on this matter, Your Honor, but we would, like I said, we'd look for the court's determination on that. I do apologize for that.
Well, when I look at it and I see that after 90 days of the stay being in place, the case should have been dismissed. It did not seem as if the plaintiff was exactly rushing to get the stay lifted. So saying all to say that Ms. Baker, yes, ma'am.
I was in contact with my caseworker every month. I was checking in, and I have proof of all of those. I have her personal phone number. And at one point during my case, because she couldn't get information from the rental property, they had to switch my caseworker. So my caseworker ended up getting changed, and I had to resubmit all of my information, which I did promptly. I did literally that same week that she contacted me. And even a new caseworker reached out to the rental property, and they refused to still send the ledger. And in order for me to go get the ledger, it involved me taking time off work, which would have been unpaid because it was a temporary work contract that I was in. And I was, like I said, working 12 to 14-hour days to try to make money in order to pay rent and pay any of my, I was off of work for sickness. I was hospitalized. And so a lot of my bills were behind. And so I was trying to make money to pay a lot of my bills up. And so I have been working very hard to try to get all of this taken care of. And this was completely out of my hands. The day that I was able to actually go in and go get the ledger is the day that I did, because my temporary work had finished. I finished my contract. And that same day is when I went in and got the ledger and was able to give it to my new caseworker.
So Ms. Baker, how long have you been back to work?
I've been back to work for 3 months. Before that, I was hospitalized and I had no way of working. And I have an immunodeficiency disorder where I can't even work around a large group of people.
Ma'am, when was the last time you paid rent?
It says it stated back in April.
Are you
from
in a
the ledger.
position to pay any rent right now?
I will be in a week. I was able to pay up my priority was paying my car note back up, so it would not get repossessed, so that I could go to and from work.
Mr. Morton, over your objection, I'm sure if you want to put a full objection on the record, that's fine. The court will adjourn this matter one time out to October the 19th, 2022 at 9 a.m. Ms. Baker, that's just to allow you some time to have your application processed. I will take you at your word that you made efforts to get the necessary paperwork and that you've been back to work. But this will be the only adjournment continuation of this matter that's now been pending for almost 6 months.
Thank you,
I'm sorry.
Your Honor.
Your Honor, as the court has stated, we would object that, but we also understand the court's decision in this process.
But Ms. Baker, at the October 19, 2022 hearing, 9 a.m., back on Zoom, back with me, the court will entertain Mr. Morton's or his firm's request to enter judgment. There will be no reason to delay it any further. I just would rather you have your application process, payment made, in either a conditional dismissal or dismissal straight out versus entering a judgment where you are indicating to the court that you did everything you could to get your application processed. Anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Baker?
No, Your Honor, thank you.
Have a good day and good luck to you, ma'am.
You too.
Mr. Morton, that's the only thing that the court sees for you this afternoon.
That was the only case that we had listed for this time, Your Honor.
Thank you. Have a good day, sir. Ms.
You
Baker,
as well.
feel free to go. Attorney Purnell.
Hello,
Ma'am, state your name for the record.
Sharnita Purnell.
Ms. Purnell, this is 223-284 LT. This is Barrington versus Purnell. Your case was scheduled at 11:15. It was called at 11:45. You were not present, ma'am.
Yeah, I just got home. I just got off of work.
The plaintiff appeared timely and appropriately on their request to lift your SARA stay, which has been in place now for 63 days. The court lifted the stay inasmuch as your landlord indicated they have not received payment in full. They further indicated that there's $3,613 in rent due and owing, $165 in court costs for a total of $3,778. Ma'am, have you received an update from the SARA agency?
Yeah, I talked to them this week. They were waiting for the apartment to send over the ledger. I just talked to the apartment and they just sent it over.
Ma'am, the court has granted the plaintiff's request for entry of default judgment. Mr. Katz's office will send that over. It will indicate that you need to pay the $3,778 or vacate the property by October 10th, 2022. Once the plaintiff's office sends that proposed judgment over, court will sign it. A copy will be mailed to you at the address that appears on the court file. Once you receive that judgment, the court would suggest that you submit it to the agency that you made your SARA application to, advising that you are now facing removal from the property if that amount is not paid by October 10th. Do you have any questions, ma'am?
No.
Thank you. Have a good day.
You too.
Thank you. This is a recall of 223237 LT Gateway versus Davis.
Your Honor, Ms. Davis and I had a very fruitful conversation in the breakout room. The difficulty that we're having, that according to Kathy McCoy, the manager of the townhome community, is that recently the SARA money that's been approved and to be paid within 2 weeks to 3 weeks, as per SARA, isn't coming in. It's not coming within 2 or 3 weeks. Some of it hasn't come yet, and some has been received in the past. But in this particular matter, Ms. Davis has indicated that on the 12th of September, SARA approved a an amount of $5,600, $5,600, yes. And said that paid within 2 to 3 weeks. Well, 2 weeks have already passed. In 5 days, it'll be 3 weeks. It's still shy of the entire amount owed. Ms. Davis indicates that she can make the deficiency of $700. She can make that payment on the 7th, Friday, the 7th of October. And we've also been told in the past, I think we've heard this in proceedings as well, that Sarah tends to be prompted faster if they have a judgment in hand, and even more so with a writ, but I'm not talking writs here right now. I'm just talking judgments. So the concern that Ms. Davis and I have is that the money won't be forthcoming. I personally don't have approval from our manager, and I think manager is getting great pressure from corporate now at this late stage of the pandemic to receive the Sarah funds. And so we're inclined, as is Ms. Davis, if we could, to go forward with the entry of a judgment, which would give her until the 10th of October, and Sarah until the 10th of October. Ms. Davis can make her payment on the 7th, Friday the 7th. I think that's when her paycheck comes in. And that would be beyond the 3-week period, substantially beyond the 3-week period that Sarah is supposed to pay their share. That does not mean that if the money doesn't come in on the 10th, that Ms. McCoy has to instruct me to send a writ to the court. There is some leeway there, as we all know, but I think we need to put a little bit of pressure on Sarah at this point, and Ms. Davis is agreeing with me on this. I did explain other options with her.
Ms. Davis,
Yes, ma'am.
you had an opportunity to speak to the attorney. What's your position at this time?
I'm completely on board with the placing the judgment in to get the wheels turning a little faster for Sarah. So I agree. I agree with my attorney on it.
Well, wait, I'm not your attorney. Ms.
I'm
Davis.
sorry. I said
Okay.
my apologies. It just came out. I agree with the attorney about how to proceed with the judgment and for October 10th.
So ma'am, are we entering this judgment as a consent judgment? This is what you're agreeing to?
Yes, Your Honor.
Mr. Burnkrantz, and because you're on Zoom, there is not a signed judgment. Are you authorizing his office to sign the judgment on your behalf?
Yes, Your Honor.
Mr. Burnkrantz' office will present a consent judgment to this court that indicates that there's rent due and owing of $6,132. That plaintiff is entitled to $167 in court costs for a total judgment of $6,299. Ma'am, because the apartment is represented by an attorney and you are appearing improper, 3 days will pass before this judgment is final and enforceable. If you receive a copy of the judgment, it is not what you think you agreed to, you may reach out to the court and indicate so in writing. Anything else, Mr. Burnkrantz?
Your Honor, just for purposes of marking the correct box on the judgment, was there personal servants in this matter? Do you know?
There was.
Okay, thank you, Your Honor.
Anything else, Ms. Davis?
No, Your Honor.
Thank you, ma'am. You have a wonderful afternoon. Thank you for your patience.
You
today.
too. Thank you.
Thank you.
Thank you, Ms. Davis. Thank you, Your Honor.
This is 223241 LT. This is Gateway versus Raquel Daniel.
Hello,
State your name, please, ma'am.
Raquel Daniel.
Mr. Burnkrantz, the court notes your appearance for the record. Today is the day and time set for hearing on plans requested with the Sarah stay that's been in place now since July 27, 2022. 63 days have passed. Has your client received either payment in full or notification that Ms. Daniel is not eligible for financial assistance?
We have not received payment in full. We have indeed received notification from Sarah on July 27, 2022 that the Sarah application was denied.
And sir, how much rent is owing to your client?
$4,827 plus $167 in costs for a total redemption figure of $4,994.
Ms. Daniel, raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Ma'am, you heard the attorney indicate that your SARA application was denied. Is that accurate?
That's correct.
And you also heard him indicate that there's past due rent of $4,827. Is that accurate?
Yes, I believe so.
Ma'am, inasmuch as your SARA application was denied, this court is required to lift the SARA stay. Additionally, inasmuch as you acknowledge that the rent cited by the attorney is $4,827 is due and owing, there remains no triable issue.
I did
And the-
apply. I'm sorry.
Go ahead.
I did apply for the ERAP program. I was approved for the ERAP program. I did have to re-enter it because for some reason they said that I only applied for the month of June. So this was the 23rd of September I was approved. I had to go back and decline the reward because they said I only applied for the month of June, and I was not aware that I only applied for June. So I went back to re-enter the months that are missing for my rent payments, and they did say that it would take probably up to 10 days to re-review my reward.
So 10 days from the 23rd?
That's correct.
Okay. But ma'am, where we stand right, I'm sorry, you're shaking your head, sir?
No, I'm just saying we are unaware of the ERAP application. Kathy would have advised me.
Yeah, I told Kathy about it. Kathy said that even I talked to the ERAP people, the ERAP said they do not go through landlords, they go through tenants only. I do have the information in my email if you want it to be sent to you. But I did talk to Kathy about it. I spoke to her. She have been knowing that I've been in an ERAP for a month now. I have already communicated with her. But she said that they didn't notify her. And I did call them and ask them why wasn't my landlord notified. And they explained to me that they do not go through landlords. They only go through tenant for the ERAP program. So that's why she didn't know. And I had to personally inform her and let her know that I was going through the ERAP program.
Mr. Bertrand, how would you like to proceed?
I'd like to proceed with the entry of a judgment. No hard feelings, Ms. Daniel. Kathy, our manager, has advised me on numerous occasions that her office has never received any payment from the ERAP program. Any payments that ever came in were from the SARA program.
Ma'am, again, inasmuch as you acknowledge that that is the amount of rent that is due and owing in this matter, plaintiff is entitled to entry of the judgment after hearing with rent to retain possession, $4,827, $167 in court costs for a total judgment of $4,994. I made a notation of file that you've applied for ERAP. So even after Mr. Bertrand's office submits the judgment, it will indicate that you have until October 10th, 2022 to pay or vacate. You might want to follow up with the ERAP people once you receive a copy of the judgment. And if you're in a position to make payments, you should do that, ma'am.
Okay.
Anything else in this matter on behalf of the plaintiff?
No, Your Honor.
Anything else, Ms. Daniel?
No, ma'am.
Have a good day.
Okay.
This is 2232430 LT. This is Gateway Townhomes versus LaShawna Strange.
Hi, I'm here.
Ma'am, turn your video on and state your name for the record, please.
Okay, I'm trying to turn it on now. With my first name, LaShawna Strange.
Understood. Sir, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place since July 27, 2022. 63 days have passed since that stay was in place. Mr. Bertrand, has your client received either payment in full or notification that Ms. Strange is not eligible for financial assistance?
We have not, Your Honor.
Ms. Strange, inasmuch as more than 30 days have passed and your landlord has not received either payment in full or notification that you're ineligible for financial assistance, this court is required to lift the Sarah stay in this matter and will do so. Mr. Burnkrantz, how much rent is due and owing to your client at this time?
The balance is $2,296 plus $167 in costs for a total redemption figure of $2,463.
Ms. Strange,
I'm sorry, I got kicked out.
raise your right hand for me, please. Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Burnkrantz has indicated that there's $2,296 in rent due and owing at this time. Is that in a correct amount?
Yes.
Ma'am, inasmuch as you admit that that is the correct amount, there remains no tribal issue of fact and plaintiff is entitled to entry of judgment in that amount, $2,296. There's also $167 in costs due to the plaintiff for a total judgment of $2,463. Have you followed up with the Sarah agency to determine the status of your application?
Yes, I actually got approved for it on the 6th of this month. And they said I got the email saying it would be deposited to my landlord in 2 to 3 weeks.
And what was the amount approved?
$28.20.
$28.20?
Yes.
If that amount was approved on September 6th, we are now 1, 2, 3, 4 weeks past that. The court will enter the judgment as indicated, but I've made a notation in the file that there is amount approved that is sufficient to satisfy the judgment. Once you receive it, you should once you receive the judgment, you should submit it immediately to the Sarah agency so that they know that you are now facing eviction if that amount is not paid in full. Anything else on behalf of the plaintiff?
No, Your Honor.
Any questions, Ms. Strange?
Will I be able to pick up that the paperwork?
They typically mail it. If Mr. Burnkrantz' office emails it today or tomorrow, the court signs it as soon as it sees it. If you want to check at the counter, come into the court and check at the counter on Friday for a copy. I can't guarantee that it'll be, but it should be done by that point.
Okay.
Otherwise, it will go out in the mail.
Okay.
Okay,
All right, ma'am. Thank you.
we're all set, ma'am. Have a good day.
You too.
I'm trying to think of who was the other lady who said she wanted a copy. Let's think. This is 223244 LT. This is Gateway versus Adams.
I'm here.
State your name for me, please, ma'am.
Aya Adams.
Today, thank you. Mr. Burnkrantz, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now since July 27, 2022. 63 days have passed. Mr. Burnkrantz, has your client received either payment or full or notification that Ms. Adams is not eligible for financial assistance?
We have not, Your Honor.
Ms. Adams, have you followed up with the agency that you made your Sarah application with for an update?
Yes, I have been trying to get an update, and I also went through FIA for the SCR assistance, but I have not heard back from that.
Ms. Adams, turn your video on for me, please.
Okay, I'm sorry. I thought
That's okay, ma'am. Inasmuch as more than 30 days have passed and your landlord has not received payment in full or notification that you're ineligible, the court is required to lift the Sarah stay and will do so. Mr. Burnkrantz, how much rent is due and owing to your client?
$5,080 plus $167 in costs for a total redemption figure of $5,247, Your Honor.
Ms. Adams, raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, you heard Mr. Burnkrantz indicate that $5,080 in rent is due and owing. Is that an accurate amount?
Correct. Yes.
Ma'am, inasmuch as you acknowledge that that is the inaccurate amount of rent due and owing, there remains no tribal issue of fact, and the court is required to enter judgment in favor of plaintiff and against defendant with rent to retain possession of $5,080. There's $167 in costs in this matter for a total judgment of $5,247. Mr. Berncrant's office will submit a judgment reflecting those amounts to the court for entry. Once the court signs it, a copy will be mailed to you at the same address that appears on the file. Once you receive that, the court would encourage you to reach out to the agency that you made your SARA application to, indicating that you have now had a judgment entered and face an eviction if that money is not paid out to your landlord. Anything else on behalf of the plaintiff?
Nothing further, Your Honor. Thank you.
Any questions, Ms. Adams?
No, thank you.
Thank you. We're all set, Ms. Adams. Have a good afternoon. Mr. Berncrant, that's the last case
You
that this
too.
court has on the docket. Thank you, ma'am.
Yes, that is the last case. Thank you very much, Your Honor. Have a good day.
Thank you. That concludes this court's docket. Courtroom 1 stands adjourned.